Ladies and gentlemen, gentlemen and ladies, ladies and gents, we got a little bit of Dion, I believe in all kind of stupid stuff, Warwick in the background. Hey, I didn't say it, she said it. She talked about all the dumb things she believes in. Okay? So, anyway, let's go ahead and have a conversation for a moment, shall we? I am doing this video specifically for our mortgage people. Those of you who are facing foreclosure, there are several remedies out there. I'm going to give you one that you'll have to do a little bit, not a lot of study on. Okay? You'll have to do a little bit of study. Don't go to my video to understand it. Go to the actual case law for your state to understand it. You already know how to go into case text. I'm going to contact case text because I think they should be paying me to be advertising them so much. Man, look at all the advertisement I'm doing for case text. Anyway, ladies and gentlemen, those of you who are facing foreclosure, you don't understand what's going on. And so I was just speaking with a young lady this morning and explaining to her the situation. You did this to yourself. Nobody committed fraud against you, and nobody's attempting to commit fraud against you now. Wait, hold on. Hey, Dion, give me a second, okay? You go and talk to Mr. Sanders while I talk to these people for a second. Some of you didn't understand what I just said. You think that I'm joking. You think that I'm making this up. You did this to yourself. Those of you who are facing foreclosure, and those of you who are not facing foreclosure, but will face it in the future, you did this to yourself. Those of you who faced foreclosure in the past and went through foreclosure, you did this to yourself. You did that to yourself. You're doing this to yourself. Ladies and gentlemen, everything that they're doing is 100% legal. Do you know why? Anybody? Yeah, I know. Because you think you're smarter than the average bear. So you're thinking that what I'm saying is a bunch of bull and that I'm trying to play on words here. I'm not playing on anything. I'm about to tell you the honest truth. You signed those documents. There was no fraud. All of the information was right inside the document and you did not read it. All you did was sign everything away. Go ahead. Go ahead and tell me who pointed a gun at you. No. Go ahead and tell me who was getting ready to pour gasoline on you and had a match in their hand. Go ahead. Go ahead and tell me how somebody grabbed your hand and signed your name to that document, forcing you to sign it. No. Go ahead and tell me who told you you couldn't read it before you signed it. Go ahead. I dare you. Don't come up with no excuse, because everything that you would say from this point on would be an excuse. And nobody got time for excuses. So I'm here to tell you how to get your anuses out of that mess you got yourselves into. Nobody put you in that position but yourself. And until you realize that, and some of you are too stubborn and some of you are too stupid to realize it. So until those of you who are intelligent, those of you who, you're right, I made a mistake. You're right, I should have read that. You're right, I shouldn't have signed it without knowing fully and asking more questions. Okay, I'm talking to those of you who are those individuals because you have some intelligence. Let me minimize this for a second. Well, you know what? No, I'm not going to minimize it because you see this QWR? This is important because this is being put up on the internet for you guys. The first place we're going to put it, you'll find it on SAA. You got to go to SAAlimited.com PDF section. That QWR will be under the contract section. However, you have to go to SAAlimited.com/PDF and then you have to go to the contracts to find this particular QWR. Want y'all to hold on because some of y'all just ain't gonna get it. No matter how much I yell it and scream it, you ain't gonna get it. That right there that I just put was for the file to be on SAA. For those of you who are at SATCOM, okay, we're going to put it under the mortgage document. Mortgage complaint and laws. So that's where you're going to find the QWR is under number 8, mortgage complaint and laws. Okay, that's where it will be. That is that current QWR. Now we put the other QWR, and I think I put it in this folder yesterday. Okay, it will be there as well, but this is to make sure if I made any changes that this will go ahead and put the current document up. And apparently I made no changes, so the current document is up. So now that you know the document is up, now we can do the video, now we can talk. Ladies and gentlemen, because you signed the documents, I've been trying to tell you that there is one way out. Now, it entails you admitting that you did something you didn't have the authority to do. But that's okay, because when you did it, you weren't trying to deceive anyone. You actually believed that you had the authority to do it because the bank told you you had the authority to do it. That's right. The plumber did it. You had the authority to put someone else's property up as collateral to buy your home. Now, if you did a refi, that's different. This is not talking about this. This part right here is not talking about you who have done a refi or who've done reverse mortgages. This is you home buyers who bought for the very first time. As I said in the previous video done yesterday, there was an individual who did a mortgage, and the person had a cosigner. And the cosigner was a relative of this person. And she, the person buying the property, and the cosigner, people don't understand, a cosigner is the collateral on the loan. When they tell you need a cosigner, the cosigner is the collateral on the loan. The Non-Judicial Foreclosure Act, which means that law that in the non-judicial states, they can't use that to foreclose on you. That's not a secured loan. That loan is secured by an individual. That loan is secured by an individual. The individual is the collateral. The bank can't own that individual, nor can they take the home. Shh. We got more to talk about, so hold on. Just explaining a scenario so that you guys can understand it. Ladies and gentlemen, we're going to open up a document. If it lets me open it, because I've been having some problems with Word ever since I did the registry clean, because I haven't restarted the computer. If it lets me open it, there is a document. It is not the QWR request. That's not the one we're opening. As a matter of fact, this document that I'm just now pulling up, we're going to put this one online as well. So this is the sample assignment document. That's what we're going to put up here as well. This is not going to be on SAA because this ain't got nothing to do with SAA, okay? But we're going to put it here, and we're going to put it in both folders. It's a sample notice of assignment document. Sample notice of assignment document. It's going to be an 8-point space mortgage. So it's 8 points, okay? Because they're not in numerical order. So you need to understand, it's just going to be under mortgage complaint. Under the mortgage complaint folder, I'm not going to put a link underneath the video. You're just going to have to go to the PDF section of the SATCOM website. If you don't know how to get to the PDF section of the SATCOM website, go to the SATCOM website. It tells you how to get to the PDF section. If that's still not good enough, then you simply type in on the EON channel PDF and watch the latest video, and it'll show you how to get to the PDF section. No need for me to go through all of that. Well, all the time you took to say all of that, you could have just told us. You better believe I could have, and I chose not to. Now, go talk to your mama and be upset with her, but I ain't got time for it. Ladies and gentlemen, many of you have seen this document before. The names have changed to protect the innocent. However, you've seen this document before. Many of you. And if you've seen this is the document talking about equitable rights. Okay? And in this document, talking about equitable rights, what you are going to do, make sure of something. I gotta check something out. Yeah, this is the word doc, and that's the way it's supposed to be. Okay. Well, of course, there's no Bololi, Howie, and no Clyde, Zawi. Those are just names that I made up, ladies and gentlemen. Like I said, to protect the innocent and the victimized, and the addresses have all been changed and all that other wonderful stuff. Ladies and gentlemen, this is called equitable redemption. Equitable redemption, each one of you, you have equity in your property, right? You've heard that before. Hey, how much equity you got in your property? Okay, so you know you have equity in your property. This ain't that! So get that out of your heads. This ain't got nothing to do with that equity. You have equity in your property because you're the owner. You're the equitable owner. That's why you have equitable interests. We're talking about the interest you have in the property. Remember when we talked about assigning the collateral? Well, you can only assign property as collateral if you have interest in the collateral. So because you're the owner, you have interest in the home. Not interest as in dollar signs, but interest as in my name is on that property. So you have equitable interests. What's equitable interest? Don't worry about it. Just know that you have it. Okay? And under the equitable interests assignment right of a property, you have the right, just like you have the right to assign collateral of a property that you own or have an interest in, you also, just like those of you who full faith and credit, the United States government have the equitable interest in that full faith and credit. Shh, don't worry about it. You have the right to assign your equitable interest to anyone whom you choose. I'm going to tell you, let it be a family member whom you can trust. Not one whom you do trust, one whom you can trust. What's the difference? Well, a person you do trust, you've been trusting that person for too long and you've been letting them get away with a whole lot of stuff. No, you want a person whom you can trust, who've proven time and time again, they ain't out to get you, they ain't materialistic, they ain't gonna kick you out of your own home. That's the person you want. By law, you have the right to assign your equitable interest to whomever you want. So, give the person $10 and say, look, I'm going to assign my equitable interest to you. We're going to work out an agreement, verbal agreement, where I'm going to get to stay in my home. I'm just going to assign the equitable interest to you. I'm going to stay in my home. Now, let me tell you how this works, ladies and gentlemen, so that you get it. You have to give something of value. That's why you do the minimum of $10. Now, we did this for equitable and statutory rights. Now, you may not understand that. Let me make sure, because I gotta, yeah, this one didn't do it, and I'm upset. Oh, that's right, I didn't save it. Okay, watch this. I gotta do it. Okay, we're gonna take the word equitable. Watch this. I gotta re-put this document up, ladies and gentlemen. It's only in 3 places, so I gotta re-put it up. Okay, now, equitable. Yeah, let's paste it, and then we'll put. All right, thank you. All right, goodbye. Okay, that won't work. You guys weren't supposed to be hearing that whole conversation. Ladies and gentlemen, I thought you all were on pause, but I'm going to leave it. I ain't going to change it. You heard what I just did. You heard what I just did, sitting up here trying to figure out to call somebody. That was all real. Sorry. That was me going, what am I doing? Let me see, let me call this person. And then I typed it in my phone and I called him. Yeah, but that was golf. And y'all see how me and golf we talk. Y'all didn't hear what he said. He said he dropped everything when I called. I told him you can't be doing that. That seems irresponsible, dropping everything. He said nobody got hurt. I said, well, that's a good thing nobody got hurt. Just wanted to let you hear his side of the story. Because he told me when I first called, he said he was doing nothing. I said, that's a shame because he's in the real estate, y'all. How can you be in a real estate and this doing nothing? That's a surely a waste of somebody's good earned money. Ladies and gentlemen, then I found this. This is what I was looking for. Georgia's law doesn't provide a statutory right to reinstate a loan prior to the sale, except on high-cost home loans. But many security deeds, contracts, like common uniform single-family Fannie Mae, Freddie Mac security deeds, provide the borrower the right to cure the default after acceleration and reinstate the loan. Ladies and gentlemen, I know that the right of redemption exists. Georgia might say it don't have the right to redeem, but of course they do. You have the right to reinstate the loan. You have the right to bring the loan current. You have the right to pay off the home. That's called the right of redemption. Okay? It says the holder of the mortgage must send notice to the borrower of its intent to foreclose. The borrower will not get much advance notice. If you don't cure the default, the lender will accelerate the loan. Accelerate? Slow down, mother. Did you know the speed limit? Okay. Georgia doesn't have a law that gives the borrower the right to reinstate. Doesn't matter. The contract gives the borrower the right to reinstate. So, there's a lot going on because I don't know if this information was up there, but we're going to put the information online. Ladies and gentlemen, in the contract, let me say it again. Ladies and gentlemen, in the contract, there is your right to reinstate because you put it in the contract. Not because they put it in the contract. You put it in the contract. That's the first thing. Now, I need to put it in 2 more places, so y'all just bear with me. It's got to go here. Or is it 1 more place? I think it's just 1 more place, because it's only 2 places here. So it's just going to go in those 2 places. The 3rd place was SAA, but this document don't go on SAA. So now you have the current document. Ladies and gentlemen, you're creating, when you use the QWR, you're creating a new contract. You're creating a new agreement that gives you the right to redeem your property upon proof that there was any debt owed on the property. That non-judicial foreclosure act is so unconstitutional it's pathetic because it takes away your ability to defend your claim. See, what the courts are saying, well, it's proof that there's a debt and all we have to do is have proof of a default. Well, we do the same thing with our contracts. We prove that there's a debt, we prove that there's a default, and then they want to say, oh, hold on, you can't do that. It's that double standard. So for those of you in Georgia and those of you in other states, you have the right to redeem your property. You just have to do it the right way. So we're putting the documents up there. What have you got to lose? This is not about throwing everything at the wall to see what will stick. Okay, we done had our days of doing that. This is about you recognizing that there are 2 sides of the law. At one point, they say you can't do a thing. You don't have the right to do this. You don't have the right to do that. However, I want you to pay attention. I told you, I know because I've looked at the standard forms, the single-family home loan guarantee forms that are usually issued by Fannie Mae and Freddie Mac, okay? Or what's the other one? Guinea Mac, whatever them other, and Penny Mac and all them companies, they use the standard form. It gives you the right to bring your mortgage current, and it also gives you the right to redeem your property after sale. Okay, go ahead and look at the contract. Doesn't matter, ladies and gentlemen. Within a year, all you got to do, pay attention, just do the assignment of your interest in the property. especially if you're still listed on the documents as being the owner. If you're still listed on the county recorder's documents as being the owner, that means you have an interest in the property. If your deed, your warranty deed, is a standard form issued by Freddie Mae, Ginnie Mac, Freddie Mae. Remember, Fannie Mae and Freddie Mac and Ginnie Mae, those companies are government because the government took over those companies during the great so-called fiasco with the savings and home loan fiasco. You remember that? When they took over all of them, and Fannie Mae and Ginnie Mac and Freddie Mac, when they took over all of that, what they did, pay attention because some of you guys are not paying attention. They brought in the single family home loan guarantee. Even though that's been around for years, decades, they brought it back, ladies and gentlemen. Because they brought it back, that gives you the right to offset that debt. Why? Because the clause is in the pudding. The pudding is in the clause. It says you have the right to redeem or to cure the default. See, I said the right to cure deed. Okay. Yeah. We're going to do this last search, then I'm going to get off of this because I do have to go lay down. Like I said to Garth, it had you guys on pause, and I looked in to see the light blinking. I'm going, what the, anyway. Uniform, Freddie Mac, security deed, provide the borrower. Hold on, this is in Georgia. I know I just said this, okay? But here's NOLO law saying the same thing, okay? This is an attorney, Amy, okay? This is what she say. Before the foreclosure crisis peaked in 2010, federal and state laws regulated mortgage servicers and foreclosure procedures, where the laws were relatively limited and tended to favor the foreclosing lenders. Now, however, federal and state laws heavily regulate loan servicing and foreclosing process, and most state laws gives protections to the borrowers. Yeah, whatever. The servicers generally have to provide the borrower loss mitigation opportunities, account for each foreclosure step, and strictly comply with foreclosure laws. Strictly comply. You can't foreclose on my home if I didn't own the collateral. Just can't do it. It's against the law. Also, most people who take out a loan to buy a residential property in Georgia sign a promissory note and a security deed, which is like a mortgage. These documents give the homeowner some contractual rights in addition to federal and state legal protection. Georgia foreclosure is mostly likely to get the right to a pre-foreclosure. Nobody cares about any of that junk. Okay? So don't get caught off guard. Okay? What is pre-foreclosure? Nobody cares. Don't care. Don't care. Move on now. Sorry, got to get past all this. This is junk. Federal mortgage servicing laws and foreclosure protections. Under the federal mortgage servicing laws, the servicer must contact or attempt to contact you by phone to discuss mitigation options. You tell them all, no, you better put it in writing and send it to me in the mail. No later than 36 days after you missed a payment, and again 36 days after the following delinquency, no later than 45 days after you missed a payment. The servicer has to inform you in writing about loss mitigations. Hey, you got an opportunity to cure this mother. Okay, now, they give you all these breach letters, and when does the foreclosure start? Well, the foreclosure begins 120 days. Remember, because 180 days, they can charge it off. Not my fault. Now, hold on. Pay attention. I want y'all to understand. This is federal, not state. So it has nothing to do with what Georgia says, okay? Because your home loan, sorry, if it was Freddie Mac, Ginnie Mae, any of that, not state, it's federal. If you default on your mortgage payments in Georgia, the lender can foreclose using judicial or non-judicial methods. However, judicial foreclosure work, or how judicial foreclosure works, nobody cares. You got to go to a judge. You don't get a jury, but you should get a jury. So civil lawsuit. A non-judicial foreclosure is basically, hey, you ain't got to go to no court. They're going to do an administrative process on you. Yes, ladies and gentlemen, it's called the administrative process. Administrative procedure. All they do is papers. Mailing papers and giving notices. Okay? Notice of intent to foreclose and 10 days attorney fee notice, publication and foreclosure sale, generally, blah, blah, blah. The lender makes a candid bid. The lender can bid up to the total amount owed, including fees and costs, or it may bid less. In some states, which the lender is the high bidder at the state but bids less than the total debt, it can get a deficiency judgment against the borrower, subject to some limitations. See below. The lender is the highest bidder. The property becomes so-called real estate owned. REO. Okay, ladies and gentlemen, we're not concerned about any of this junk. We're concerned about, we're going to do equitable redemption day one. We're going to say, hey, hold on, homie. In Georgia or any other state, hold on, homie. You ain't got no right to do this. Show me that there is still a debt. I done paid you. I done paid you 10 times over. So my accounting shows that you've been paid. So show me that there's an outstanding debt. You didn't lend me no legal tender. You didn't lend me nothing of value. Go ahead, show me what you loaned me. We loaned you dollars. What you mean? What species of dollar did you loan? Ladies and gentlemen, there are all kind of dollars. A peso is a dollar. The United States doesn't have a patent on the word dollar. Y'all are going to have to get with the program and understanding the argument. You're going to have to challenge the fact that you did not own the collateral. You did not have an interest in the collateral when you made the loan. So you could not put the home up as collateral because it was not a home loan. It was a personal loan, which means it's unsecured, which means they cannot use the non-judicial process with you. That's what you need to understand. That's what I'm trying to get you to understand. So that means you have the right to do the equitable redemption. Why? Because even though they claim it doesn't apply, you're creating a new contract. Because somebody has changed the terms of your agreement. Somebody has brought in the Non-Judicial Foreclosure Act when that wasn't part of the agreement. The Non-Judicial Foreclosure Act was never part of the agreement. Are some of you starting to understand what I'm saying? Thank you. I appreciate that. Hey, guys, I do have to go. I definitely have to go lie down for a couple of minutes. So I'll speak to y'all the next time, okay? It's been a long day. Bye-bye. Adios. Sayonara. Arrivederci. Hasta la vista, babe. You know what I'm saying.